This video is about statutory interpretation. I am Rajesh. I am a practicing company secretary, and this video would be useful for CS executive students. We have also made a video on what is a Bare Act. Watch that video. It will help you understand the current video on interpretation. The link of the Bare Act video is in the description box below. Now, what is statutory interpretation? In simple terms, it is nothing but the interpretation of a statute. Now, enacted laws are drafted by legal experts, and it is naturally expected that it will leave little room for interpretation. But in reality, that is not the case. There are a lot of possibilities that there are some confusions, that there are some ambiguity, and naturally it leaves room for interpretation. Salmon says, interpretation is a process by which courts seek to ascertain the meaning of the legislature through the medium of authoritative forms in which it is expressed. So, the very purpose of interpretation is to ascertain the meaning of the legislature, that is the enactment or else the act, through the medium of authoritative forms. That is, we look at the words, we look at the context, we look at the sentence, we look at the provision, and we arrive at a particular interpretation. Now, what are the basic principles of interpretation? One is that the statute must be read as a whole in its context. You are not supposed to read it in bits and pieces. You will have to read the entire statute. You will have to read the statute in its entirety. Now, for example, if a particular provision says that subject to the provisions of section 26, then it means that you are also supposed to read section 26. So you will have to read the entire act in its context and in entirety. Then statute to be construed to make it effective and workable. Normally what happens is when we are stuck with a problem, now let us assume a student is going through a particular provision of law. He is not very comfortable with that, or he is not able to arrive at a proper interpretation, then naturally he'll think that we'll skip this particular portion. Or he is working out a problem. He might think that this is not correct, or the answer that is given in the study material is not correct. So the basic presumption with which you are supposed to start is that the statute is always correct, or the enactment is always correct, because it has been drafted by legal experts. So any provision that you are interpreting, you will have to make sure that it is effective, or your interpretation is effective and it is workable. That is, you should not decide, or you should not arrive at a conclusion that a particular provision is not correct. It should be made workable. If meaning is plain, then effect must be given to it irrespective of the consequences. That is, if there is no confusion, if there is no ambiguity with respect to a particular provision of law, then effect must be given to it. You are not supposed to worry about the consequences. You should not say if 30% of tax is made or deducted on a particular person, then he is going to suffer so much. No, it is not the duty of the court. The court is there only to interpret. They are not supposed to look at the consequences. Then they are also supposed to, the court is also supposed to look at the intention of the legislature. That is, what is the purpose for which a particular enactment has been brought into force? What is the object for which a particular enactment has been brought into force? Look at the intention. Only if there is some sort of confusion, or only if there is some sort of ambiguity in the provision of law. If there is no confusion, or if there is no ambiguity, and if the language used is very clear, very plain, then there is no need of interpretation. A statute is an edict, or else it is a will of the legislature, and the conventional way of interpreting a statute is to seek the intention of its maker. As we all know, this concept of separation of power, there are three organs. One is the legislature, the other one is the executive, the third one is the judiciary. The legislature makes the law, the judiciary interprets the law, and the executive executes the law. So one organ is not supposed to usurp the jurisdiction of another organ. And the best way of interpreting a particular statute by the court is to seek the intention of its maker. That is, what was the need for the maker? That is, what was the need for the legislature to bring about such a piece of legislation? Find mens legis, just like we say mens rea, a guilty mind. We are supposed to find out the intention of the legislature. If at all there is some sort of ambiguity. If a provision is open to more than one interpretation, then the court has to choose that interpretation which represents the true intention of the legislature. You can very well see that the sentence starts with if a provision is open to more than one interpretation. Naturally, it means that if the provision is not open to more than one interpretation, the language used is very clear. The language used does not create any sort of confusion, it does not create any sort of ambiguity, then there is absolutely no need for the court to interpret. They will have to literally go by what is given in the statute. And if at all there is a possibility that it gives you possibility that there are possibilities of more than one interpretation, then the court is advised to look at the intention of the legislature. The function of the court is only to expound and not to legislate, because the legislation would be done by the legislature. The court is supposed to find out only the purpose for which the legislation has been done. Once the enacting process is over, the legislature becomes functus officio, that is, it is no longer in force so far as that particular statute is concerned. So, naturally, it does not mean that you cannot go back to the legislature. Naturally, you can go back to the legislature to get that piece of enactment amended or to get that piece of enactment repealed. But only thing is, you will have to go through the legislating process. Now, legislation is actuated with some policy to curb some public evil or else to effectuate some public benefit. Now, what is the purpose of bringing about a legislation? Naturally, it is to curb some public evil or else to effectuate some public benefit. That is, either it should benefit somebody or else, if at all there is some sort of evil, it should put an end to that particular evil. The judges are not expected to be creative in their approach. The court or else the judge might be an expert in interpretation, but he is not expected to be creative in his approach. So first he will have to look at the words, find out the meaning of a particular word, find out the meaning of a particular provision. If there is some sort of confusion or if there is some sort of ambiguity, then he will have to look at the intention of the legislature. When he is actually looking at the intention of the legislature, he need not be creative, or is rather not expected to be creative. But literally, it is impossible to anticipate fully the varied future situations. When a legislature is made, it is not possible for the legislature to find out or to anticipate the future situations. So naturally, there would be room for interpretation. Now, intention of legislature thus assimilates or it brings together two aspects. One aspect is carrying the concept of meaning, and the other aspect is carrying the concept of purpose and object. First one is find out the true meaning of a particular word, find out the true meaning of a particular provision in its context. If you are stuck somewhere, or if you feel that there is some sort of ambiguity, or if you feel that there is some sort of confusion, then you look at the purpose and the object for which that particular legislation has been brought into force. If at all there is no confusion, if at all there is no ambiguity, then you can strictly stick to the meaning of a particular provision. The process of interpretation thus combines both literal and purposive approaches. Literal is where you simply go by the word, where you simply understand a word in a particular sense in which it is being understood in the common arena. You don't go beyond the meaning of a particular word. If at all there is some ambiguity, only then you look at the intention of the legislature. Thus, we say that law should not only be observed in letter, but it should also be observed in spirit. The question is whether to look at what the words mean or to go beyond and look at what the legislature intended. That is, whether you are supposed to stick to a literal interpretation or you are supposed to go beyond that and find out the intention of the legislature. This art of interpretation is very tricky. It is something like your parents. Your parents, when you were young, would naturally would have told you not to lie. But there would have been situations when they will naturally be at home. Their neighbor comes and they'll tell you or your sister to tell them that your dad is not there at home. Then you are stuck there. You'll be wondering whether you have to tell a lie or you are not supposed to tell a lie. So this interpretation is very, very similar to that. You will have to know when you are supposed to interpret and when you are not supposed to interpret. There are chances or there are situations when you are supposed to interpret, and there would be situations when there is no need for interpretation. There is a very fine or very thin line between the need for interpretation and uh, the interpretation not being needed. Then what is the basic structure, or what is the basic principle on which you go? When the words are clear and when it is unambiguous, that is, it does not create any sort of confusion, then the courts should not busy themselves with supposed intention. They are not supposed to look beyond the literal meaning of the word. They don't have to look at what could have been the intention of the legislature, because the words are very clear, it is unambiguous, it is not creating any sort of confusion. But when the words are unclear, or when it is ambiguous, that is, when it is creating some sort of confusion, then it is safe to have an eye on the object and the purpose of the statute, or the reason and spirit behind a particular statute. When the words are not clear, then you look at the intention of the legislature. According to Blackstone, the most fair and rational method of interpreting, that is, he says, how you are supposed to interpret a particular statute, is by exploring the intention of the legislature. He says that you are supposed to find out the intention of the legislature. But how do you find out the intention of the legislature? Through the most natural and probable signs, which are either that is, the natural signs and the probable signs which are there in the statute, are the words, the context, the subject matter, the effects, and the consequence, or else the spirit and reason of the law. That is, you interpret a statute in such a manner that you try to find out the intention of the legislature. And how do you find out the intention of the legislature? From the words that have been used in the statute, the context in which it has been used, the subject matter, the effects, and the consequences, or the spirit and the reason of the law. A bare mechanical interpretation of the words, devoid of concept of purpose, will reduce the most of remedial and beneficent legislation to futility. If you are strictly going by the literal interpretation without looking at the very purpose of the enactment, then the very purpose for which that particular enactment has been brought into force would be reduced to futility. That is, it will be a waste of time. Now, for example, labor legislations are there. Why do we have labor legislations? Naturally, labor legislations will tilt in favor of the employee. Though a particular law is not supposed to tilt in favor of anybody, here in case of a labor legislation, two parties are the employers and the employees. Naturally, it is expected that it should not tilt in favor of anybody, but the very purpose of bringing that a labor legislation is to protect the interest of the employee. So, when a labor legislation is being interpreted, the court will have to look at the purpose of that particular enactment, and then a particular provision of law will have to be enacted. But when they are interpreting a particular provision of law, or when the courts are interpreting a particular statute, they will have to keep in mind that they do not usurp the legislative function under the disguise of interpretation, because the legislative function will have to be done by the legislature, and the act of interpretation should be done by the judiciary. One organ should not usurp the jurisdiction of another organ. Cardozo says that judge is not to innovate at pleasure. He is not supposed to find out something new at pleasure. Just because he feels that he is very good at interpretation, he need not interpret all the time. He is not a knight errant roaming at will in pursuit of his ideal of beauty or of goodness. This particular slide I wouldn't be explaining, because there is some sort of beauty in this language, and the person who is going through this slide will have to understand the concept, and he will have to enjoy the beauty of the language. Therefore, in their task of interpreting and applying a statute, the judges or else the court will have to be conscious that in the end, the statute is the master and it is not the servant of the judge. So they will have to keep that in mind, and keeping that in mind, they will have to proceed with interpretation. In the next video, we will study the rules of interpretation covering primary rules and other rules. Thank you.